Okay, it's 3 o'clock now, so I think we will start. Welcome to this joint webinar organized by the ETUI and the Amsterdam Institute for Advanced Labor Studies, EAIAS. My name is Maria Nikolova. I'm Communication Officer at the ETUI, and I'll be your host today. This webinar replaces, due to the circumstances, the final conference presenting the results of this comparative research project on personal household services in 10 EU countries. Those are Belgium, Denmark, the Netherlands, Spain, Germany, France, Finland, Czech Republic, Slovakia, and the UK. The project, coordinated by EAIAS and at the University of Amsterdam, has been carried out before COVID-19 changed our lives. But it has a lot of relevance for the current situation. In the COVID pandemic, more people have come to realize the importance of domestic and home care workers. There is a substantial increase in workload, and at the same time, those workers play a crucial role in the prevention and the fight of the pandemic. I will leave it to Ana Muñoz, a professor at the University Carlos III of Madrid, to introduce the project in a minute. In what follows, we'll hear more about the comparative analysis of personal household services regulation and policies by Francisco Javier Gómez Abelleira, professor at the University of Carlos III of Madrid. Then we will go into the case studies with Mina van Gerven from the University of Helsinki, who will present the Finnish case, and Clémence Ledoux from the University of Nantes presenting the French case. As the added value and aim of such conferences is to discuss the conclusions and of the project with the stakeholders in the relevant sector, we will hear the views of Aurélie from the European Federation for Services to Individuals, and Mark Bergfeld, Director Property Services and UNICARE at Global Union, Europa. As you see, we have a lot of speakers today, so I would like to ask everybody to stick to their allocated time so that we can also leave some room for questions at the end. We have already received some questions from the participants in advance, but you still have the possibility to submit your questions to the panelists in writing by using the Q&A pin on the bottom of your screens. Now, without further ado, I'll give the floor to Ana Muñoz for a brief introduction of the project.
Thank you so much. Well, I would like to share my presentation. Well, thank you so much, and welcome to the Job Quality in Personal Household Service Toward Better Regulation, this webinar. I would like to say something about the research for telling the conclusion, the findings. First one, this project is a European...
I'm sorry, Anna, can you just put the presentation as a slideshow, because we don't see it very well, just the slideshow.
I'm not sure how.
On the bottom, just yeah, just when you, or
yeah.
Or here, presentation con diapos, yeah.
Yeah, sorry. Well, I start again.
Perfect, thank you very much.
Thank you. Well, I would like to say something about the research and the team. This is a European project, Job Quality in Personal Household Services Toward Better Regulation. This project has been coordinated by the University of Amsterdam, in particular Professor Martin Kewney and Nuria Ramos, and we cover the period 2018-2020. Well, the main research question is how to improve job quality and how to fight informality, because you know this sector is very dramatic in the practice. And then we try to have some tools in order to avoid or reduce precarious work. We have specific objectives The first one provides insight in the experiences of 10 European member states. We analyze collective bargaining and social dialogue. And finally, to discuss our findings with the European social partners. Today, we have a very relevant opportunity to share our findings. Took into consideration the international law, the ILO Convention 189, and domestic law. Concerning the European Union, we took into account the Directive on Transparent Working Conditions and the Directive 89 about health and safety, because you know this directive excludes the situation of domestic workers. We combine a methodology using data. Sometimes it's very difficult to find data about those domestic workers in some countries, and we have analyzed regulation and case law. In addition, we have made interviews with social partners, workers, and family organizations. And we have organized 2 webinars. One of them is this webinar today, and the next webinar it's on 25 June at 3 p.m. and we will analyze other cases into the research. Many thanks for your attention, and thank you so much.
Yes. Can you stop sharing your screen?
Yeah.
Thank you. Thank you. Thank you very much for this overview. Now we give the floor to Francisco Javier Gómez Abelleira for his comparative presentation, comparative chapter presentation.
Hey, thanks, Maria, and welcome everyone to this webinar. Good afternoon, everyone. My job here is a challenging one because I have to present a comparative analysis of regulation across 10 countries, and I only have 10 minutes. So, and this is especially challenging for 2 additional reasons, or for 2 special reasons. The first one is that the 10 national reports are extensive and really rich in content. And the second reason is because there is a great variety, a great diversity of experiences, of regulation, of policy, of practice across these 10 countries. So the first thing I'm going to do here is, after sharing the screen with you, my presentation here. The first thing is to provide some context here. And I want to share with you this figure from the Slovakian report. And what you can see here in I guess, a very clear manner is that household services are strongly connected with the social care services in place in a given country. But, and this is important, the services can also be procured outside the domain of the social care scheme in place. So when we try to move or to translate this structure into the work relationship and ask ourselves about the employment status of the workers, when we go down to the labor market, what we see here is basically a binary division between the households acting as employers or the households acting as clients or recipients. I think this is a very important division. I think this is the most important division across countries. Because what I have seen in the reports is countries in which the preponderance is on the more formal side of the slide. So the preponderance is a situation in which the household is a client or a recipient, there's a third-party provider, be it public or private, and there is usually an employment contract with the worker. So this is we can call it a common or regular situation with a common or general employment contract. By contrast, when we move to the less formal side of the slide, we have natural persons in the household acting as employers. And in this case, we have a lot of problems. We see a lot of problems in the different countries. Because in this situation, when the household acts as an employer, the worker sometimes doesn't have any formal employment contract. So what you have there is an informal, undeclared relationship. And if you are lucky, you find a formal employment contract, but with a lot of protection gaps. So even in the best scenario, in the best situation, in this less formal side of the slide, when you have a formal employment contract, you have a lot of protection gaps. So this idea of protection gaps is an analytical framework adopted in the German report by Karen Gerling and Claudia Weinkauf. And it's important to know that this happens in a formal employment relationship. We're not talking about informal relationships. We're not talking about undeclared work, which is of course worse than this. So we are talking about the best scenario in which you have an employment contract. So we have basically here 4 different types of protective gaps. The first one is the gap in employment protection. Here, this gap is seen not only in domestic regulations, but also in the European law. For instance, I can give you 2 examples. One, an old example, but very important example from the Occupational Safety and Health Framework Directive of 1989, which excludes domestic servants from its scope. And this is one of the original sins of European occupational health and safety law. And another example, more recent example, one of the last social directives, the Directive on Transparent and Predictable Working Conditions, which states that member states may decide not to apply the obligations, certain obligations of the directive, to natural persons in households acting as employers, where work is performed for those households. So you have gaps at European level, and of course you have many gaps at domestic level. For instance, in terms of wages, in terms of hours. For instance, you have in France different legal framework for domestic workers whose regular weekly hours is 40, while the normal pattern is 35. You have specific problems with live-ins in UK and Spain. For instance, sleep-in shifts are not considered working time. You have gaps in terms of termination of employment, with usually less protection for dismissal for domestic workers than for other type of workers. So you have gaps in health and safety. For instance, the mentioned exclusion from the scope of many regulations in countries like Spain or UK, and the application instead of general civil law rules, common duty of care, liability for personal injury, and the like. This is gap number 1. Gap number 2 relates to social protection. And here, of course, the worst scenario is undeclared work, in which case you don't have any protection at all. For instance, the Czech report informs that it is expected that a household will register as an employer for a domestic worker. The problem is that the administrative burden imposed on an employer, in this case the household, discourages the formalization of working relations in the sector. So you have these incentives for the employer, but also for the employee, because many employees, many workers in many instances prefer cash in hand and no deduction for social security contributions. So we have to establish as a general and basic principle for decent work, full access to all social security branches, including unemployment, which is a gap in some countries, for instance, in Spain. And here we have good examples, maybe in France, maybe in Finland, and next speakers may talk with more authority about these examples for establishing strong incentives to register employees. Gap number 3 relates to enforcement and institutional, what I call institutional avoidance. Of course, the extreme form of institutional avoidance is informal work, or bogus self-employment, or the employment of unauthorized or undocumented migrants. But here we have problems with labor inspectorate and access to courts. For instance, in France, we read in the report that when work is performed in occupied dwellings, inspectors may enter only with the prior permission of the occupants. I think this is a regular or the general rule in most countries. In Finland, for instance, deficiencies in supervision, limited human resources in the inspectorate is evident in the report. Access to courts is another problem. Access to courts is very uncommon in practice, even when the case is clear in favor of the worker. For instance, the dismissal of a worker during pregnancy. And finally, gap number 4, representation gaps. This is very important. This is crucial. Industrial relations is very poor in most countries for domestic work. You have absence or low presence of union association and representation. You have NGOs and charities instead doing assistance with immigration process, with legal counseling, with bureaucratic paperwork. You have very, very few examples of collective bargaining, of actual collective bargaining for domestic workers. Maybe in France, for instance, a collective agreement dating back to 1999. In Germany, the report says that they not even cover the majority of those in formal employment, not to mention those in informal employment. However, the collective agreements can act as a point of reference for private households as employees. And even in Spain, a country in which we have a lot of sectoral collective bargaining, the sector of domestic work is one of the few without any collective bargaining. So what about this? What do we do with these gaps, these protection gaps? Well, from a legal perspective, and I'm a lawyer, I think this is a case for discrimination. And we read this from the Dutch report, which I found really interesting. Dutch regulation contains some exceptions to normal employment law and social security for part-time domestic workers. For instance, payment of wages during sickness is limited, protection against dismissal is minimal, etc. So, since it's mostly women who work as domestic workers, the main impact is obvious on women. So, what about indirect discrimination in this case? It's clearly a case of indirect discrimination, and we know from the theory about indirect discrimination that indirect discrimination can be justified only if there is objective and proportionate reasons that justify this unequal or different treatment. Do we find them in the cases mentioned in the different reports? In most cases, the answer is no. So this could be a matter for some legal action in many cases. This is the main question in this project, and this is my last slide. How can legal regulation, public policy, and social partners' action improve job quality and fight informality in this sector? 4 ideas. Strengthen collective voice. Association and collective negotiation are crucial. Second, extend most employment law to domestic work. Every exception, as mentioned before, should be well justified, taking into account the principle of proportionality. Number 3, put in place incentives to declare and register with the social security, tax authorities, etc. And 4, very important, improve inspection procedures and tools. Thank you very much. Back to you, Maria.
Yes. Thank you. Can you stop sharing your screen? No, not stop sharing. Yeah. Okay. Thank you very much.
Sure.
For this, and thank you also for keeping the time. You're all doing great so far.
It was challenging.
Sorry?
It was challenging.
Yeah, but you did very well, I think. So now we go into the 2 of the case studies. So we start with the Finnish case. Nina?
Yes, hello. Let me share you my screen. Yes, this is it. Here we go. So, greetings from Helsinki. I would have rather be in Brussels today. I love Brussels, but unfortunately, Helsinki it is, which is not bad either. So, my name is Mina van Gerven, and I have done I have done the Finnish case. And I am currently a professor of public and social policy in University of Helsinki. And let me see. Let's go. Yes. So let me start very, very briefly by giving you the context, because context matters a lot when it comes to doing these kind of things. And basically, if you look at Finland, we are talking about small numbers, of course. So if you look at the sector itself, and the statistics of it, which is quite difficult to actually interpret what this sector is about. But there are some figures about having a sector what the size of 2.4% of the labor force in Finland. So it's a small sector, but it's traditionally a very strong sector with respect to being linked to the public services. And for a very long time, these kind of services have been provided by the local governments. So therefore, this formal employment that we were talking earlier has been very, very strong from the beginning on. And therefore, also the legal framework has been reasonably okay, and there are some indeed gaps which have been filled by ILO activities afterwards, where we go in a moment. But basically, from the 1990s onwards, we see in Finland, as we see in many other European countries, that there is a tendency towards a marketization of these kind of sectors and in these services. And basically, this has meant in Finland and in many countries that, well, basically states are retrieving for providing these services, and there are new service actors, public and private, who are taking part of fulfilling these gaps. And the future in Finland is rather bright, given the fact that Finland is aging quite rapidly. So we can imagine that this sector is going to grow in the future. Therefore, it's also important to know what is going on. So I guess we were collected as part of this project because Finland actually has ratified the ILO's convention. And they did that already in 2015, so 8th of January as a 17th country in ILO, and 5th of Europe, we basically already ratified that. And this ratification was actually really part of these steps that the Finnish government was doing in order to removing exceptions and promoting the principles of equality and equal treatment in the legal regulation. So basically, the whole story in Finland is very much a textbook case of tripartism. So the process of ratification was very smooth. It included all the right persons, all the right actors, tripartite actors. And basically what they did is they changed the formal law, which was separate for the household workers, and basically brought them back to a general labor law. And by that, of course, according equal status with domestic workers, with other workers. And this all happened very smoothly and nicely. So in that case, Finland can be seen as a very good case, or even a better case of regulation. So everything went according to book. And we also came up with some good ideas of how to, for example, go against the grey economy by providing tax deductions and providing service vouchers in order to make people, those working in the sector, but also those using these, to be going wide, so to speak. But what I want to do today is to actually question whether regulation is enough. And I think the Finnish case makes it painfully evident that actually is not the case. Regulation is not the case, that it would solve all the problems. So in order to improve the rights and the job quality on this sector, what actually comes after the regulation is equally important, namely to guarantee the effective implementation and making sure that authorities who are monitoring these conditions and job quality, that they are well resourced. So despite, in the Finnish case, of the strong protection of the workers in this sector, at least in the formal employment that we were talking earlier, we see that the deficiencies in the enforcement of these rights is really a major obstacle in Finland. And this basically drives also this kind of persistent vulnerability of the workers in this sector. And I want to share you three quick main findings from my research in order to show what is going on here. So basically, my interviewees, who were all key stakeholders related to this process, were already mainly from the beginning on telling me about stories about insufficient supervision and monitoring of this sector. So the national and regional supervising authorities, of course, we have them in Finland, and they are very well established, but they lack resources. So the main attention goes to monitoring services in care facilities, for example, in care or companies, but it leaves very little room for controlling services at domestic setting, which is the problem. So therefore, it's also difficult when we are talking about the private sphere, it's difficult for authorities to actually go in and intervene. Another problem in Finland we actually discovered is that there are a lot of issues relating to the service chain, usually using subcontracting services, especially these in cleaning businesses. So even though you are able to monitor and make sure that the service providers are doing their job, but if they subcontract these services to another provider, what really happens a lot in this sector, it basically says that these activities actually go outside of the primary chain and there is very little inspection there. So this is really clearly a problem. The second trend, what we found is basically that in the last 2 decades or so, we really have witnessed a general trend towards greater deregulation and flexibilization of the labor market. And in our interest of sector, of course, it is also often going together with precariousness, and often, at least according to our respondents, could lead to fewer rights, worsened conditions, and less job quality. And the PHS sector, so the sector that we are looking at is of course considered as a low paid job sector. So days are usually long and the pays are very low. And this basically has been going together, the growth of this sector in Finland, to growth of these kind of low paid jobs, and what one of my respondents called as the forced flexibility. So basically what this means is that if you work in this sector, that basically you need to be flexible. You just have to accept the conditions that might be less favorable than you would like them to be. And thirdly, and this is a very, very dear to my heart point, is that basically when we talk about this sector, we talk about work that happens at the private sphere. And in this sense, it makes the sector very and potentially a territory of more vulnerability, precariousness, and informality. That's also the core why we, and Nuria and others, they started to start looking at it. But therefore, of course, it is very important to understand what is going on at the margins. And this flexibilization is a problem for the whole sector, but we see that predominantly the problems lie within the migrants from third countries, who are the most vulnerable workers in this sector. So the Finnish system, unfortunately, has a mismatch between employment regulation, migration regulation, and the labor market demands. So basically, under the Finnish law, for example, in order to be eligible for a work permit, you have to work full time. But jobs in this sector often are 0-hour contracts, or very small contracts anyway. So basically, it makes the migrant workers very dependent on their employers for work permits and such, and also therefore make them very vulnerable for exploitation, especially when work happens at the private sphere, out of the sight, if you may. So let me conclude. Work at the private sphere indeed is a risk in itself, because it makes it as a territory of more precariousness and informality. So therefore, the legal protection is a key. It's utterly important. But the Finnish case also shows that as strong as the principles of protection and equal treatment are, as they are in my country's legal framework, as weak they remain to be, if the deficiencies in monitoring and practical implementation and the mismatch of these policies are not abolished. So therefore, Finland shows a strong protection at the core for the public service providers with the permanent contracts and safeguard from the labor unions. And these workers, of course, I do acknowledge that they face risks becoming overburdened and everything that goes with this sector. But on the other hand, they still are better protected than the fragile migrant workers at the margins. And I will give you the final sentence here. Migrant workers, especially from the third countries, they might be out of sight, but they definitely should not be out of the heart. Thank you very much.
Thank you, Mina. This was a very beautiful ending. Okay, let's go to the French case now and see whether the issues are similar or totally different. Clémence?
Yes, thank you. I'm trying to share my screen. Do you see it now? Do you see my screen?
Yes, we see your screen. Maybe just put the slideshow on.
Yeah.
Yeah, but we see it, yeah.
Sorry. Okay. So thank you very much for giving me the opportunity to present the work Rachel Krupka and I did on the for PHS. So I would like, first of all, thank all the social partners and people in the ministries we interviewed for this campaign of interviews, and also those who I had seen in previous campaigns. So what are the social partners doing for PHS workers in France? First of all, before explaining their action, it's important to understand the different statuses of the declared workers belonging to the PHS sector in France. So you see on this screen that households can employ care or domestic workers themselves. It's a kind of private employment relation. Or households can receive a service from a provider organization, which can be a public body, a non-profit organization, a for-profit organization, or self-employed. Different legal statuses correspond to this employment relation. So in the case of the private employment relation, the workers are very partially covered by provisions included in the labor code in France. Some of them apply, but very few. But these workers are also covered by a collective agreement, which has been extended. So it applies to every worker directly employed by a household. Of the providers, workers working in local authorities are covered by the civil codes. Workers working in non-profit associations are covered by the labor code, but also by the main collective agreement for the home health sector, hereafter called the BAD, Branche de l'aide à domicile. And workers working in the for-profit organization are mainly covered by a collective agreement specific for for-profit organization, hereafter called the SAP, Convention collective des entreprises de services à la personne. On both the BAD for non-profit and the agreement for for-profit, SAP have also been extended, so applying to all employers and workers. Of course, I'm speaking here only about workers' rights for declared workers. As in other countries, there are undeclared workers, but in France, we have policy instruments incentivizing the declaration of the workers, so that the number of undeclared workers is probably less important than in other countries, even if it's difficult to measure it. So I'm not going too much in details about this incentivizing instruments. They are very well described in other reports like the FARVAC report or the ADPHS reports. But for example, the fiscal benefits are very important in this incentivizing procedures. And but if I come back to the first slide, you see that we have 3 collective agreements existing in the sector. So a branch agreement for private employment, a branch agreement for non-profit providers, and the branch agreement for for-profit providers. And we see that in France, we have a very fragmented trade unions and employers organizations negotiating all these collective agreements. So in France, since the 2008 and 2014 reforms, the possibility to negotiate and perhaps to block a collective agreement depends on the representativeness of social partners. And for the trade unions, it's based on votes. And we see that even if in the main national confederations, for example, the CFDT or the CGT, it's not the same federation within the confederation, which is negotiating the different collective agreements. For example, it's the CFDT Public Health, which is negotiating the non-profit agreement or the BAD, and it's the CFDT Service negotiating the private employment agreement. And also, of course, for the employer side, we have also fragmented employers. So what are the interrelations between these agreements and the general labor law? As I said, you see it here in this column. People directly hired by households, so belonging to the SPE, so this private employment relation, they are only partially covered by the labor code. It means that there are major provisions which of the labor code which do not apply to them. For example, the definition of effective work, working time, part-time, night work, overtime, rest period, and so on. And the social partners managed to introduce this collective agreement, which has been extended. And in this agreement, there are a number of rights from which the domestic and home-based care workers were excluded from. So there are rights from which the workers were excluded, which has been introduced in the collective agreement, but in many cases, nevertheless, this agreement remains far from general law. And for workers working for providers organizations, of course, labor law apply. But in France, the recent labor law reforms have gradually transformed the hierarchy of standards so that it's possible to have a company agreement which would be different from what the branch agreement is prescribing. If we look further in these specific rights for domestic and home-based care workers, I just will speak about rights which are very important for the workers. We see what I was saying about this specific definition of what is work for the workers directly employed by households. In the collective agreements, there is a possibility to pay, for example, the workers at a rate at 1/6 of the normal wage, minimum wage, and the collective agreement states that it is compatible with daytime employment. And then there are also responsible attendance on nursing duties, which are also paid 2/3 of hourly wage. By contrast, for providers, there were not such provisions included now in the agreements. If we look at other workers' rights, travel is very important for the workers. Of course, in the private employment relation, travel time is not considered as working time. There are no mileage allowances, but for providers, travel time can be considered as working time under certain circumstances. I'm not going too far in details. And there are also mileage allowances. There are also in the collective agreement trainings, levies, which have been adopted by the social partner, but you see that it's at different levels, and the non-profit organizations are dedicating the most important percentage for training their collective agreements. And we also see, comparing the number of hours, average hours worked, and the entitlements, that workers directly employed by households have more difficulties to be entitled to unemployment and pension, But the social partner in the collective agreement for private employment, so the SPE, have introduced a specific pension scheme, but the monthly pension in this scheme, the average monthly pension in this scheme is very low. It's 1,012 euro per month, so it's not very much. We should also say that in France, there are more details in the report. So, approval and extension of collective agreements function differently according to the different collective agreements. And for the non-profit, there is the necessity to have the approval of the Ministry of Solidarity and Health. It means that there is really a hidden hand of the state behind collective bargaining for this branch in France. And it means that when you see the employers' organizations in this branch, they say, we can't increase the wages because we are limited by this approval. We know that if we would go too far, the ministry will refuse the approval. It's not the case for the other agreements. And something which is very important in France is that in all these three collective agreements, the social partners manage to create and increase branch funds. It means that it's money coming from the gross wage, which is going to a fund and which is then financing employers' organizations and trade unions. And these funds are dedicated to the development of the social dialogue, a better knowledge of the agreements, the structuration of the sector. So it can give the possibility to the social partners to better know the sectors, but also to pay expertise and also to pay lawyers. And for example, one of the trade union was able to suppress something that was in the collective agreement for the for-profit organization, and it costed a lot of money. And you see that it's an important measure for the social dialogue in France. But you see also that this percentage is very different according to the three collective agreements. So it's much more important in the private employment, the collective agreement for private employment. And so if I try to conclude what we learned from the French case for these three branches of collective bargaining. So for the private employment relations, so the social partners were able to include a set of workers' rights in the collective agreements, from which the workers were excluded in the labor code, but they didn't catch up the process of general law, and also many areas of general labor law are not applying to these workers, so it's incomplete. For the non-profit associations, we see that in the collective agreement, the social partner have little room of maneuver. There is this hidden hand of the state behind collective bargaining, but this social partner have put importance on training. And for the for-profit one, we see that the private employment the collective agreement for private employment has inspired the employers' organization mainly, but this organization face trade unions which are professionalized, which are resourced, which are institutionalized, and which were able to refuse some agreements and also to go to court to suppress the ones they considered as unfair. So, and they are also very active on going to courts. So in France, say 189 hasn't been ratified. There is not so much debate about the convention in France. But we see social partners which are very institutionalized, embedded in the French industrial relations systems. And it's a system where trade union membership is not so much important in order to give a trade union the possibility to negotiate a collective agreement. It's much more the votes than the membership, which is important. And so even if the workers are not so much unionized, there are unions which are able to negotiate a collective agreement. But as in other countries, nevertheless, the question of the implementation of these agreements is still in question. So thank you very much for your attention.
Thank you, Clémence, for this presentation. Now we will turn to the social partners. It was they were mentioned quite a lot in those presentations, and I'm sure they're very eager to give their views from their respective perspectives. So we start with Aurélie.
Yes, hi. So thank you very much for inviting me today. So to shortly introduce myself. So I'm Aurélie Decker. I'm the director of EFSI, which is the European Federation for Services to Individuals, which is the voice of the PHS industry at EU level. So we do represent national association, employers organization, PHS providers, as well as company involved in the development of PHS. So first of all, building and sharing knowledge about PHS, about domestic and care work is particularly important. The sector is in constant evolution. It's subject to numerous pressure. It suffers from under-recognition, and therefore a project such as this one is always welcome, as it contributes to bridge the knowledge gap on PHS. For years, EFSI has been supporting knowledge building and knowledge sharing, and I really wanted to congratulate project partners for the quality of the reports, because from what I've been able to read, they're all very well documented, and it's very useful. And so based on the presentation we just listened to, I wanted to highlight some issues raised in the project, which are of particular importance. The first thing I wanted to stress is that reports illustrate the fragmentation of the legal frameworks and the multiplicity of employment relationships existing in PHS. And even in countries where we can find successful public intervention measures, it's really hard to have a comprehensive overview of the working conditions and of the social protection and benefits that PHS workers enjoy. And this is really a gap for us. As it was mentioned in the introduction, during the COVID-19 crisis, PHS workers have been at the forefront of the fight against the pandemic, and the recent estimate published by the ILO revealed that up to 50% of domestic workers in Europe were significantly impacted by the crisis, and be it through the reduction of working hours, reduced incomes, or even the loss of their jobs. And what is particularly important is that among this 50%, 90% only, if I could say, are undeclared or informally employed. So that means that 41% of formally employed domestic workers were significantly impacted by the crisis. So I think these figures really shows how even when they are formally employed, they are in a precarious situation. We have witnessed many political statements saying that PHS workers are essential workers to our society. But we have seen emergency measures adopted by governments to mitigate the effect of the crisis on workers. And unfortunately, in many cases, PHS workers were not entitled to those measures, or at least not at the beginning. I mean, further action of social partners have been required to grant some support to those workers. And one of the reasons, and it has been stressed by several speakers, is that in many cases, even when formally employed, the status of PHS workers still has many exemptions from regular labor standards. And that is the main reason why. And that leads me to the second point I wanted to highlight is the ILO Convention 189. This convention requires that domestic workers enjoy conditions that are not less favorable than those applicable to workers generally. And this is really at the heart of a discussion about enhancing working conditions in the sector. The project, from what I've seen, investigates how the ratification process of the ILO Convention is conducted in national levels, and even when it has been ratified, what are the barriers to its effective implementation. And I have to say that this analysis, this investigation comes at the very right time. In just about a year, we will celebrate the 10th anniversary of the convention. And I think that it's our duty as a representative of the sectors to make it a political momentum to make people more aware of the situation in the sector. And finally, I also see a little bit that the project was touching upon the question of the conciliation between finding the right balance between the quality of work and the affordability of PHS services, which is really a key issue if we want to tackle informality in the sector. And I think this is really a topic in which we need more investigation on it. I've seen that many reports were unable to provide estimates on informal work, because of course it's a tricky question, but it's an information that we need when we are discussing the issue, discussing with national authority, how can we put in place the good incentive? How can we improve the working condition if we don't know how many workers are currently employed informally? So, but I know this is a difficult research question, but it's something that we would like to see more grasped by researchers. But just to conclude, I just wanted to say that the findings of the project will definitely feed our reflections in the coming months on the ongoing work on how we can improve the formal development of the PHS sector in the coming years.
Thank you very much, Aurélie. Mark, over to you.
Hey, hello everyone. I'll try to keep myself as short as possible because I know that Maria wants to, quit at 4 on the dot, and I think there's plenty of.
We have until quarter past. So
until quarter past. Okay. Yeah. So I think my starting point is really the COVID-19 crisis. And at the beginning of the COVID-19 crisis, if you think about the kind of commentaries that were put out in the mainstream media, such as the New York Times or the Guardian, lots of commentaries said that COVID-19 crisis is the great leveler, that it will, affect everyone. It affects everyone the same. But effectively, what we have seen throughout the COVID-19 crisis is that it actually has exacerbated existing inequalities. That what we have seen, it exacerbates existing inequalities in health, and secondly, it exacerbates existing inequalities in the labor market. And this is particularly the case for migrant and women workers working as domestic workers and care workers in people's homes. And reports from our unions in the PHS sector has shown time and time again that the women working in people's homes did not have access to personal and protective equipment, for example. They did not have access to COVID-19 tests. And ultimately, in the absence of that, they were actually could potentially act as spreaders of the COVID-19 crisis, going from house to house and helping older people, helping the disabled, and helping some of the most vulnerable people in our society. And as a consequence, we as UNICARE, who represent the home care section of the PHS sector, EFAD, our sister union, who represents the domestic workers, EFSI and Aurélie's organization, as well as their sister organization, EFE, actually took an initiative as social partners at the European level and came up with a joint statement trying to outline some of the political floor of what we actually need to get, what PHS workers and what the industry actually needs to manage the crisis. I think that was a very good starting point. To go into some of the kind of contributions that you have made, and I think all of them were absolutely excellent. I would first of all like to take up Francisco's idea of the representation gap. So what we know for a fact is, and I think it becomes very clear in your research, as well as in Clémence gave us the entire great overview of how collective bargaining functions in the PHS sector in France, we see that the industrial relation systems created in different European member states are actually industrial relation systems which were created by men and for men working particularly and predominantly in the manufacturing sector and in a Fordist industrial setting. The issue is that a lot of the kind of vertical structures that you have within within our trade union movement are actually not able to represent these workers adequately. That results in two fundamental issues. As a consequence of the structures not being able to capture these workers in their verticality, you see that alternative forms of labor organization emerge. So on the one hand, you see that NGOs take in the place, charities take in the place, or migrant worker organizations, or even informal forms of organization. So when I went to Cyprus at one point, every Sunday at the beach, there's a long, people are, mostly women workers are sitting there who work in people's households and, share food and discuss what is happening, and they resort to those forms of organization in the absence of unions. So our tasks as unions and together with the employers in the sector, is actually to create adequate forms of representation. And that means like creating at the sectoral level forms of organization that can represent both the employers and the kind of the direct employers, as well as the indirect forms of employment that exists there, as well as forms of union organization that build upon the network effects that already exist within the communities of migrant workers. The second point I would like to pick up on is Minna's point around regulation alone doesn't work. I think this is the crucial takeaway for me from this workshop or short seminar, because I actually think that we have been, as UNICARE, we have been putting a lot of emphasis on organizing these workers and trying to build their collective capacity and trying to build their individual capacity to actually try to enforce, act as kind of enforcers of regulation from below, if you want to label it, it's that. That is important, but as I said before, you cannot, as in traditional trade unions, go from workplace to workplace and try to organize all these workers. So we need regulation to actually set set sectoral standards that provide union access and that provide first and foremost the right to organize for both undocumented as well as documented, undeclared as well as declared workers. And the third point that I would actually like to take up is that is the form of trade union action. I mentioned that we had a joint statement together with the social partners and our sister trade unions, and we are particularly trying to work at the European level to inspire action at the national level in terms of professionalizing the PHS profession, in terms of trying to develop new forms of representation and collective bargaining, and working towards further recognition. For us, the key point in all of this is trying to get towards a system of sectoral collective bargaining. I think that provides unions with access, it provides employers with the ability to manage the workforce, and is actually something that can create a floor within an industry that currently doesn't have a floor, where we aren't even aware of the extent of undeclared work and labor abuses occurring within the industry. So thank you very much.
Thank you very much, Mark. That was clear, and now we have some time for questions. So I will start maybe with something that I think was not covered in the presentations about the intra-EU migration. We have a couple of questions on that. So what are your expectations regarding the intra-EU migration in the aftermath of the COVID crisis? Do you think we will see more of it now? And how do you see the problem of regional inequalities in the field of PHS, in the sense that there is a division between the old member states and the new member states, the old member states as the receiving countries and the new member states as the sending countries of caregivers, and what can we do about this specific inequality issue? Then another question on the same topic. The sector is poorly mapped and analyzed in the Central and Eastern European region. There is low participation of social partners in the discussions about working conditions of domestic workers there. And at the same time, the current pandemic revealed the importance of home care services, especially for elderly people and young children, and the sector is expected to grow in the future. How relevant are your results in these special conditions, and do you plan to expand the research to other countries in this region? So I don't know who wants to answer, or maybe on some of the aspects of this. Maybe I don't know, in more overview, maybe Anna can say something about whether you plan to expand the research, or yeah, I will unmute you.
Well, I only would like to say something about the first question. Perhaps my partner Francisco could answer the rest of the question. Of course, for migrant workers, no, and the sector, domestic workers, the most of them are migrant workers. And what about the next situation, no, for them? I think it could be less mobility, no? Because in the next months we will suffer a crisis, an economic crisis, and perhaps we will have less mobility for migrant workers. But the problem, in my opinion, is the situation for those workers into the European Union, no? Because we can see that we have a very relevant part of those workers informal domestic workers, no? Then we have a serious problem with them, and perhaps we need more regulation, more control. Mina mentioned the implementation of the regulation, no? It's a very difficult question in my country, in Spain, the situation of informal workers in this sector, and we have a problem right now, no, with them. Thank you.
Okay, thank you. Francisco, do you want to?
Yeah, I wanted to say that Eastern European and Central and Eastern European countries, I think, are well represented by two solid country reports. The Slovakian and the Czech Republic reports are really solid and rich in content. Mm-hmm. So I would suggest to take a look at these reports. I think it's worth the time. And regarding migration, yes, I think it's basically it's an economic issue. And for instance, my experience here in Spain, we have basically migration from North Africa and South America. And of course, if there are not many opportunities right now in Spain in terms of employment and the recession that is advancing in these weeks, I don't think we have much migration even for domestic work.
Mm-hmm. Okay.
Another important thing, it has been mentioned before, is that there's no domestic work if people can't afford that care. I mean, many people can't afford the care anymore. So they resort to other forms of care, like family members or things like that. And so they terminate maybe some other forms of employment that they had in place. This is happening right now, of course.
Yeah, if I may take on that, well, what you see in the Nordic countries, but also in let's say, West Europe, Netherlands, for example, you see that most of, well, there will be indeed, because of the fact that there's more push also from the governments for families to take care of each other, basically. So there's a lot of downsizing in the public services, and there's a lot of legal activity towards providing more and more responsibilities for the families themselves to take care of the elderly and so on and so forth. But if I go back to the migration issue, I mean, the Finnish case is very clear that it has been now triggered by the Syrian crisis. So the crisis of refugees has brought a new kind of stream of people that are now being very much well, solicited for these kind of jobs. So because of the existence of a new group of foreigners in the country, which of course Finland has a very, very small history when it comes to people migrating there, because it's quite cold here usually. So that has really, you know, the migration crisis has brought a new kind of group of people who are now being finding their way to the labor market. And I think these kind of migration, because of well, in this case it was the migration crisis, but I can imagine also for the climate change and the migration that will go because of this, that is also new kind of pools of migrants that are going to arrive to European countries in the future. So this is, I think it will be only increasing.
Yeah, Mark.
Just really quickly, most native-born workers, whether they be Finnish workers or German workers or French workers, are not willing to work for that wage. So what you get as a result is effectively a segmentation of the labor market and a dualistic labor market in which these workers work within and circulate within that labor market between different households. And actually, because they cannot get their skills recognized in many cases because of their status, it means that they will remain within that labor market and have no way to go out. So one of the central strategies, both from employers as well as from union perspective, really needs to be like, how do we professionalize the PHS work, which effectively then allows these women to, you know, be empowered, allows these women to have careers and, you know, self-sufficient life and get their skills recognized. So when they move to another country, they don't start at zero again, but actually start at a different spot. And I think it's one mechanism to really close the kind of vicious cycle that we're experiencing within the sector.
Mm-hmm. Yeah, thank you.
Yeah, so just to follow what Mark was saying, indeed, I mean, many employers are working on the qualification of their workers, and they have implemented specific trainings for workers with a migrant background. for example, regarding language training, for example, which is important, especially if you provide services towards elderly people or children. And I wanted to align, because we mentioned the fact that with the crisis, the situation of informal and migrant domestic and care workers has been highlighted. And if we take the example of Italy, because Italy has launched a regularization process for migrant workers with the crisis. So, well, this is an opportunity to regularize some domestic and care workers. Of course, there are some entitlement, and I don't think that all workers will be able to be regularized, but it's a good sign, because we know that already the PHS sectors is suffering a lack of workforce, and we need new workers, and we know that demand is increasing, and that in 5 years and 10 years time we will need even more workers than that we have now. So we need to find a way to attract new workers, be they migrant or not. And in this regard, I think that one important thing, an important change which is required, is a cultural change, is the fact that we need to value those professions, those occupations. We need to, as a society, to recognize their importance, and that goes with, of course, adequate working conditions, adequate wage, and so on. But it's also that we collectively need to recognize the importance of this care and domestic work, even if it's unpaid, even if it's provided within your family by your family members. But yeah, that was
I just wanted to come back to the question of the migrants. I think it's also important to see the regional or geographical differences also within the same states. So I mean that, for example, for France, we will see a lot of them in the big cities like Paris and Marseille, but on the rural areas, they are less present. So there are also within the same country a lot of differences considering this question.
Okay, thank you very much. We still have a couple of minutes. I wanted also to introduce another question, which I also think we didn't cover so far. And this is it concerns the platform mediating personal household services. Many people are interested in that. Apparently, there are many of those platforms now. Are they included by the employers' organizations? And what are the specific challenges and opportunities of these platforms? Do they create more difficulties for instance, regulating working conditions or anything else? So. Somebody wants to say something on the platforms?
Yeah, may I say quickly, we also covered a little bit of this, because in Finland you have quite an active platform industry now for the cleaning services predominantly, and that has been that's also an area where the trade unions are trying to find a way how to assist the workers. Most of them, the workers who are then basically providing these services are foreign. If you look at the websites, they look for their employees in English, which is quite remarkable in Finland. So it's clearly targeted to foreign staff, and the problems there are very much common when it comes to these kind of platform gig economies, basically forcing people to become as self-employed or focus self-employed. So they kind of are expected to take care of their own registrations, being fully self-employed, taking up all the social security issues that they should take, and making sure that they are covered. But of course, many of them do not speak the language. Many of them have problems in order to actually being able to give all the documentation that needs to be done. And there's very little activity on that. And I do hear that the trade unions here in Finland, they are trying to find a way to bring more awareness. And that's one of the things that I learned my own research that the main of the things is that you just try to get the message across for those people, that they get just more information and know what to do, but it's a very, very challenging task.
Okay. Yeah, you want to say something, Francisco?
Yeah, just a very short comment on this, because I think that we employment lawyers usually think that the best alternative is to have a direct relationship between the employer and the employee. And this is true generally, but here in this particular sector, I think that any third party providing some type of professional service is good, because it contributes to the professionalization of the relationship, which otherwise is very amateuristic from a natural person in a household, in terms of health and safety, in terms of social security, in terms of many things. So, of course, with proper and careful regulation, I think that the fact that a third party steps into this direct relationship is good.
Okay. So nobody wants to add something? If this is the case, then I think we should, yeah.
Yeah, sorry, just to quickly react about the question of platform. It's indeed a difficult question, and there's been many platform launched in the sector in the past 5 to 7 years, and there are as many different models of platform as platform exist. Some of them are, few of them are the employers, legal employers and the workers. Some of them are marketplace. Some are just intermediation platforms, so they put in relation end users with workers, and then they don't really bother about to know if the employment relationship is formal or informal. The question of platform in the sector is indeed a question in which we need more research and more analysis to really know what's going on, because even some platforms such as Helpling, which is a platform which operates in many countries, they do have a different business model depending on countries and the legislation. And we need more insight on this. And but what we have to bear in mind that if we are going to the development of those platforms, which also are an opportunity in helping for matching the demand and the offer, for example, we should ensure that there are some safeguards that those platforms do provide, ensure that the working conditions of workers are in line with the regulation, and that also users are have access to quality and professional work. But it's still well, it's still a big issue on which we should work on in the coming years. And the European Commission is having an initiative on it this year or early next year. So I hope we will be able to progress on it.
Okay, thank you. So then, if nobody wants to add anything to this, I suggest that we round up, and I would like to thank very much to all speakers to share with us their research and views on this important subject, and the audience as well to be with us today. The slides and the recording of the webinar will be posted on the ETUI website, and you will receive an email when they are available. The country reports of this project are also, as you have seen in the first presentation, available on the website of EAIAS. I would also like to use the opportunity to advertise a bit the autumn-winter 2019 issue of the ETUI, twice yearly ETUI magazine about health and safety at work, HESA-MAG. If you can see it, it contains a special report on migrant workers in Fortress Europe, with, among others, an article on the status of migrant female domestic workers in Europe and how migrant domestic workers cope with unfettered exploitation. The issue, as all other issues of the magazine, is available for free download on the website of the ETUI, and you can also receive paper copies on request. I will include all those links in the email that you will receive as a follow-up of this event. Please follow our website to learn about our next events, and goodbye and see you next time.